The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Everyone. I welcome you to the second day of our Harrisburg session here in this beautiful Capitol and this magnificent courtroom adorned with the violet Oakley murals, which I hope you'll take a moment to look at while you're here. Before the court crier calls the first case, I'd like to briefly remind counsel of a few matters of protocol. Please approach the podium when your case is called. I will give a brief summary of the case. Please begin then by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of the facts or procedural history and instead focus on the main issues on which we granted review. Counsel may rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should not repeat the same arguments as prior counsel. Previous chiefs have referred to this as the no piling on rule. Please do not interrupt the justices when they're asking you a question. We have a very active court, and a justice's question is not meant to trip you up. Rather, it indicates that there are particular issues that we wish to explore further. Our court does not permit rebuttal argument. Finally, while we have set no time limit for your argument, I will advise counsel when we've heard enough, and at that time I ask that you conclude your argument. Mr. Minner, would you call the first case?
South Bethlehem Associates versus Zoning Hearing Board of Bethlehem Township versus Central PA Equities 30. Representing South Bethlehem Associates, Mr. Timothy Stevens. Representing the Zoning Hearing Board, Mr. Lawrence Fox. Representing Central PA Equities, Ms. Catherine Gerson.
All right, you can approach. In this appeal by allowance, we are asked to determine whether the Commonwealth Court erred in finding that South Bethlehem Associates lacked standing to appeal from an adverse zoning decision, which granted a business competitor's application for 2 zoning variances, despite South Bethlehem's appearance as an objector before the zoning board. We also address whether the court correctly assessed South Bethlehem's standing under an aggrieved person standard. Please proceed.
May it please the court. I'm attorney Timothy T. Stevens on behalf of the appellant South Bethlehem Associates LP. My co-counsel in the case, the Bethlehem Township Zoning Hearing Board, is represented by Larry Fox because he complements our argument on the standing issue. I believe he's an appellant as well in this case. Since our arguments do complement one another, I think Mr. Fox is going to focus on the Bethlehem Township zoning ordinance and how that applies to this standing issue. And I will elaborate on the other issues. I think we share the same view on the Spawn case, which is the Pennsylvania Supreme Court case relied upon by the Commonwealth Court, in that we both distinguish that case in that that case relies upon the Philadelphia zoning code, not the Bethlehem Township zoning code. I think I take it a step further in that in the Spawn case, the objectors in that case were over a mile away. That's not this case. In this case, as we know from the record, the South Bethlehem Associates LP was the owner of the Courtyard by Marriott Hotel that was only 2 blocks away. It doesn't meet the strict requirement, the 400-foot rule that would give us automatic notice and automatic standing to appeal, but it falls under the line of cases, which I would call the close proximity cases, and there are a number of them that we cite to in our brief, or the immediate vicinity cases, and therefore it's our position that the Spawn case does not apply. With respect to the first issue as set forth by the court, It's the position of the appellant that the Commonwealth Court erroneously applied an aggrieved party standard that was repealed by the legislature per those sections 11005 and 11007. Those were repealed back in 1988 in favor of section, we're referring to the MPC, 10983 and 9, which I suggest should be read together. I may shorten it to that section as far as 9083 or 9089, just so we're clear on the record. So prior to 1988, as I set forth, the MPC granted the right of appeal in zoning cases to any party aggrieved on those sections that I cited, 11005 and 11007. It's set forth in Appendix E of our filings, and your honors can see there's multiple references to the aggrieved party standard that was completely repealed. It's our position that section 10908, 3, and 9 broaden the standing of a party to appeal a zoning decision when that party opposes the zoning relief at the time of the zoning hearing, which in fact the appellant South Bethlehem did in fact do through counsel, through me.
Establish that you are an aggrieved party.
And I'm glad Your Honor brings that up, in that I think it's my position that the Commonwealth Court misconstrues what I said during the latter part of the hearing.
Did you present any witnesses?
I presented cross-examination, and through the testimony of the engineering expert, Mark Bannock, I elicited testimony and evidence through his cross-examination. So I think the reference in the Commonwealth Court's opinion is incorrect in that there was indeed evidence. There was a fair amount of evidence through Mr. Bannock, the engineering expert, that established, to the extent on the second issue, the aggrieved party standard, in that he admitted that a smaller hotel could be built in a smaller building envelope. And further beyond that, he admitted that a two-room hotel up to a 100-room hotel could have been built without the need for the extensive dimensional zoning variance that we had in this case, which we know was over 50% of the amount of the setback. It was a 150-foot setback, and they requested a 76-foot variance, so it was over 50%. Beyond the mere.
Counsel, were you the original trial counsel?
I was, yes, Your Honor.
And correct me if I'm wrong, did you not enter your appearance for, what was it, South Mountain Associates?
Yeah, unfortunately, I misspoke on that particular issue. It was South Mountain, I said South Mountain Associates LP, but the correct name is South Bethlehem Associates LP. However, I mentioned at the time of the hearing other identifying characteristics of my client.
It was
which
just
really
a
should control
slip of
me.
the tongue. It was just.
Exactly. But then I went forward, and it's in the record, Your Honor. I identified the address, which was 2200 Emmerich Boulevard. The subject property is at 2401 Emmerich Boulevard, just 2 blocks away. I referenced my client as the objector. I further identified my client as being the owner of the Courtyard by Marriott Hotel, just 2 blocks away. So it's our position that it was simply a slip of the tongue. And okay, I mean, we could go further. I mean, all right. With respect to the statutory analysis of the MPC, which I may add, the Commonwealth completely skipped over, which should be a red flag to this court, in that, yeah, the key issue here is what does the MPC state? What did the legislature decide the court should follow for standing? What did the people want? And that was completely skipped over by the Commonwealth Court. The Commonwealth Court simply cited a number of cases and predominantly relied upon the farmland case, which was a case that predated the repeal of those sections that I mentioned before that had the aggrieved party standard. So it's our position that it was inapplicable, it was old law, and it wasn't following the newest version of the MPC that the Commonwealth Court should be following.
Just leave the question as to whether or not your client is a person affected Is that in your argument?
That's, it's,
Or your, or
no,
your,
good point, because there are two arguments made under section 908.3. So if you turn to the language, it's our position, that's what guides standing at this level. And if you break it down, for section 908.3, it says the parties of the hearing shall, as the mandatory language, be the municipality or any person affected, and again, they don't use the language aggrieved anymore.
right, no,
It's affected.
I agree with you. I'm over the aggrieved.
By the,
I'm over that. How is your client a person affected pursuant to the statutory language?
right, it goes back to my argument as far as the testimony that I elicited by the engineering expert, Mr. Bannock, in that he stated that the new hotel, the Fairfield Hotel, just 2 blocks away, is they just wanted a 107-room hotel. I cross-examined him, and he admitted it. Well, no, it could be a hotel anywhere from 2 to 100 rooms. It could
So
be
is
built.
that a principle of law that if your property is in close proximity to the property at issue in the zoning hearing proceeding, that you are a person affected?
Yes, but it's a matter of degrees.
Okay, so what is close proximity then?
So the proximity is, if it's within 400 feet, I get an automatic appeal. 'Cause
Right,
then an
okay,
automatic
but you're
notice.
not.
Then there's the line of cases, which I call the close proximity cases, and I cite the Plaxton case. And there's another one, which let me put on the record, because I don't think I put it in my brief. It's the Assoc case, 159A second 692. It's from this case, older case, 1960, but there, the persons in immediate vicinity, but not abutting landowners, have standing to object to the affected variance.
Okay, so in the Plaxton case, for example, what was the distance between the challenging property owner and the property that was the subject of the zoning hearing board?
I'm sorry, I don't know the actual measurement in that case, but the holding did state that the objector's close proximity provided standing as aggrieved parties. So I don't know, I'm
How
sorry.
about the other case you're relying on? Does that talk about what close proximity is?
It does, but there it refers to as immediate vicinity, so
Okay.
it's in close proximity. So it's a matter of degrees and a matter of how is that going to affect the particular property
So
or
is it
the hotel.
a question of first impression whether 2 blocks away is close proximity?
I don't know that. I would just ask the court to follow the line of cases and look at the whole record and say, well, yeah, it's in close proximity, and in addition, there
Well,
is
the
that.
trial court who knows the vicinity found that it was in close proximity.
Yes,
So you would rely on the trial court's determination of that?
that's certainly helpful, and it's also helpful that the zoning hearing board found the same thing. So they found we were in close proximity, and therefore we were not only a party, but we also had standing in the case.
Okay.
So going for, I'm sorry, I don't want to cut. Okay, going forward with 908.3, just to your point as well, in that you mentioned that section that has the affected party language, and the cases don't clearly define affected party. I would submit to the court, and it may be a case of first impression as far as defining what affected means under the circumstances. I would suggest it's something less than an aggrieved party standard. But going further in section 908.3, there's the third part of it where any person, including civic or community organizations, permitted to appear before the board. So under that standard, it's our position, we meet that as well, because at the time of the hearing, and it's right there in the record, we were permitted to be a party, we were given standing. They actually say, you have standing, Attorney Stevens. And we were able to cross-examine witnesses. I was able to cross-examine witnesses, elicit testimony, raise objections.
To that point, isn't there a difference between the ability to appear at a hearing, and can't anybody basically, or lots of people can appear at a board, but only an aggrieved person can appeal a decision of the board?
Not necessarily, because you could be, and I think Attorney Fox will add to this, in that you could be in favor of something and be a party and want to also be, have standing and support something that would be positive for your township or
Well,
wherever.
if you're a party and you're in favor of something and it's not granted, if you're aggrieved, you would have the ability to appeal.
Yeah, yes, but I don't think it's an aggrieved party standard. As suggested before, it's a lesser standard. It's either an affected party standard, or I think it goes to what the township zoning ordinance says. And if the township zoning ordinance says, hey, we have the discretion to determine who's a party and who has standing, that needs to be abided by. That's in our zoning ordinance, and it's allowed. It's allowed right here in the MPC. We can do that.
What section particularly of the MPC are you citing for the proposition that any person who appears before a board can appeal without being a aggrieved party?
It's section 908.3, the latter part of that, where it gives us basically a third, and any other person, including civic or community organization, permitted to appear by the board. Okay, so if you just show up, but you're not permitted to appear, but you would.
Any person can appear before the board, but that section particularly doesn't provide you in that section. It does not specify that you can appeal.
Good.
It says you can appeal before the board.
Absolutely. That's my point, in that 908.3 needs to be read together with 908.9, which sets forth the right of appeal, because that has language in there. 908.9 states, nothing in this subsection shall prejudice the right of any party opposing the application to appeal the decision to a court of competent jurisdiction, and it references any party. So therefore, section 908.9 gives you the right of appeal, and I would submit.
What bothers me about that argument is that you read those two sections out of context with section 1102, which is entitled Time for Appeal, Procedural Defects of Decisions. And in that section it says, appeals under this section shall only be permitted by an aggrieved person.
Excellent point, in that you look at 1102.1-A, but you have to look at all three subsections, A, B, and C, to read that in context along with the title that Your Honor just read. The title states, it's the procedural defects of decisions. I would submit, the appellant submits, that section that I just mentioned applies to procedural defects. This is not a procedural defects, it's a substantive issue. Standing, and I think we'd all agree, standing is a substantive issue, and therefore it's our position that 1102.1-A does not apply.
Anything else?
Sure. I mean, I can, as far as there was reference to Pennsylvania Rule of Appellate Procedure 501, that should control, and that there's aggrieved party language in Pennsylvania Rule of Procedure 501. It's our position that does not apply. When you hear you're challenging the Rules of Appellate Procedure, that does not apply to the Court of Common Pleas in Northampton County. The only way it could apply to the Northampton County Court of Common Pleas is if they have adopted the Rules of Appellate Procedure. They don't adopt the Rules of Appellate Procedure, and therefore it doesn't apply. And the controlling case on that point of law is the Thompson decision that's cited at 963A second 622. It's a Pennsylvania Commonwealth Court, a 2009 decision. So 501 doesn't apply. Appellant's position is, even if you apply it, which we don't think is correct, we meet the standard because of the prior argument that sections 908.3 and 908.9 did in fact enlarge the standing for an appeal. So even under the language of 501, we meet the test. because it's enlarged. You don't apply the aggrieved party standard, you apply the MPC 9083 and 9089. So no matter what, it's our position. Under 501, it's not a problem. Going further, with respect to sections 11005 and 11007, there was an argument made by Apelt CPE that those sections were replaced by section 10913.3. And I'll submit that if you look at the chart that's in the record, yes, 10009.13 does replace those sections. However, you need to read 109.133, and that is not, the aggrieved standard that's set forth there is not applicable, because when you read it closely, there's a section of that provision that applies to variances, which is this case, and special exceptions, and all it's doing there is limiting jurisdiction for an appeal that goes directly to the zoning hearing board. And that only, the appellants there are just landlords, and then not landlords, the property owners, the landowners, or if the landowner gives permission to a tenant, they have jurisdiction to take that appeal at the zoning hearing board level, and that's what that particular provision speaks to, and therefore the aggrieved party language there does not apply to a variance, which is this case. There was an argument made by Apelt CPA that we had waived our section 10908 argument, and I would submit to this court that the record is replete where we've preserved that particular issue. At the trial court level, we briefed that issue. Judge Morganelli references section 908 in his decision. At the time of the hearing, I didn't bring up specifics of section 908 because we were permitted to. The appellant was permitted to elicit testimony. We were given party status and standing at the time, so there was no reason to get into the granular aspects of section 908 at the time of the hearing. As I said before, it was definitely addressed at the trial court level. Then we get the Commonwealth court opinion, as I mentioned before, doesn't even cite to the MPC, and relies upon the outdated law and so forth. So in response to that, when we petitioned for allowance of appeal to this court, we got into even more specifics of section 908, and we cite to section 9089 that gave us the right of appeal, and therefore it's our position that we did in fact preserve our argument under section, it's 10.908, 3 and 9, based upon the record before this court.
I'm impressed by your ability to have all those section numbers memorized and to reiterate them to us, because I don't think this is an easy section of a statute to put together. But would you agree that overall, if you look through the statutory sections, that the sections that start with 10s seem to be focused on the hearing board sections, and section 11 that starts with the 11s seems to focus more on the appeals to the trial court?
Yes, I think they do. Yeah.
Yeah, and I guess to that end, I just don't know if I follow your argument with respect to the one line in section 10.908.9 that you hang basically the framework of your argument on, that says nothing in this subsection shall prejudice the right of any party opposing the application to appeal, when it's a 2-paragraph nearly section that talks about time frames as opposed to standing.
I hear you, Your Honor. It's a difficult analysis, and yes, you have to go through all these MPC provisions and just try to piece it together. And what are we supposed to do here? What I can say about section 908.9 is that it does apply to all contested or denied appeals. It doesn't just apply to deemed approvals, which I think is argued by appellee's counsel. You read that section in its entirety, and when you get to the last line that gives you the right of appeal, it's talking about the universe of challenged applications, not just deemed approval.
And then I just have one other follow-up question, and I'm sorry to take all your time, but is it your position that through the cross-examination of the party at the hearing, at the board hearing, you established a pecuniary and a substantial interest that would substantiate an aggrieved party status through that testimony?
Yes, it is appellant's position that we have done that. And a case that we rely upon, I don't know if I actually cited in my brief, I know the Commonwealth Court cited it, but I think it helps the appellant in this very argument, Your Honor. And it's the William Penn parking garage case from this court, 1975, where an aggrieved party must have an interest that is pecuniary and substantial, and that's the measure. And the important thing there is the testimony of record clearly shows pecuniary harm. I mean, we've established all the circumstantial evidence. I didn't have an expert to come and say that, but all the evidence is there that we have a hotel 2 blocks away. You can build another hotel within a smaller building envelope that's going to cause us less pecuniary harm. And that comes in a number of different measures. I mean, it's not just the income. You know, we're going to get obviously less income because you're going to have a bigger hotel 2 blocks away. When it comes to valuation, okay, so my client wants to sell. So where do I go to an appraiser. The appraiser is going to look at the income approach, and the measure is going to be less because there's a hotel 2 blocks away that's much larger than it should be under the current variance scheme.
Thank you.
I want to make sure.
Do you want to say anything in conclusion?
The other areas were just, because I didn't have an opportunity, we don't have a reply brief, nor do I have rebuttal, is distinguishing existing cases. So I did go through the record, and I think I've talked, the Grant and the Baker case are, they do rely upon Section 908.3, particularly the Grant case, which is post-repeal of those provisions, and they do cite to 908.3. So I think that's authority that, yes, indeed, that section is what controls the standard under these particular circumstances. I mentioned the Spawn case before. I don't know that I need to repeat that. I think, we're different than Spawn, and the farmland case is distinguishable because the properties were not in close proximity. We've established we are. In the Leone case that is relied upon by the Commonwealth Court and likely the appellee, definitely the appellee relies upon the Nuremberg case. Those 2 cases are distinguishable because the landowners did not participate, or the objectors did not actually participate in the proceedings. So that's not this case. Piero, that matter was before it was an older case, 1969, so it was before those repealed sections. And the Worthington case is distinguishable because of distance. They were 3 miles away.
I think we get it. So I thank you for your argument. Let's hear from Mr. Fox.
Thank you very much.
Please proceed.
Good morning. My name is Lawrence Fox. I represent the Bethlehem Township Zoning Hearing Board. Justice Donahue, you've raised an issue which is important to me, and that is that when an individual comes to our zoning hearing board, we are not constrained to have a second hearing to determine if that individual is aggrieved or even affected. Were this honorable court to establish a protocol by which Henceforth, the zoning hearing board would have to determine initially if someone is aggrieved or affected. We'd have to have a hearing within a hearing. Now, that's not what our local township zoning code requires. It's rather interesting, Madam Justice, that our code reflects at section 275-12E that among other criteria we may utilize is the fact that the zoning hearing board may unilaterally, of its own accord, determine that an individual should be permitted to appear before us. And once we make that unilateral determination, the individual, the entity, is now a party. And so your question that you raised with Attorney Stevens is very important to me, because in the present case, it's interesting, Madam Justice, the three of us have known each other for years and years, and in fact, Mr. Stevens was at the hearing, I was there, and legal counsel for the appellee, Kate Durso, was there. And at the time that this hearing took place, the zoning hearing board unilaterally determined, as was its authority, that Mr. Stevens' client should be permitted to appear. We didn't have to find that there was anyone aggrieved or that anyone was even affected.
I understand what your argument is, but that doesn't necessarily then mean that the individual or entity that you deem to be allowed to participate is a person who is affected by the application, who is then a party, who then can then appeal. I mean, somewhere along the way, somebody has to make a decision that the person is affected by the application.
And
somebody has to make that determination, and you're telling us that you don't do that.
Oh, no, quite the contrary.
Okay.
The zoning hearing board will make that determination among itself, but it does not have to utilize the criteria of affected or aggrieved. And I'd like to give you, Madam Justice,
Why would that be, since we're looking at a statute that uses the term affected?
you've read my mind. An
Okay.
individual can be affected in a good way as well as a bad way. Here's an example. A neighbor comes to one of our zoning hearings, this has happened many times, and they say, we're here because we're interested in the fact that the township or somebody wants to put in a community swimming pool, and we want you to know that we're here because we think it's a great idea. So if you, the zoning hearing board, decline to grant the remedies sought, we may want to take an appeal as a party. Now let me give you another example, if I may. Suppose that a school district wants to put up a new sign and they need a dimensional variance for the size of the sign. Many times, I've had a sign painter or the president of the sign company appear before us and say, I'm here tonight to tell you that we want to put up this sign. They don't have standing. It has nothing to do with whether they're aggrieved or affected. They didn't come with a letter of authorization from the Bethlehem Area School District. So how do I know they have any right to be in front of us? So many times we will make a unilateral decision that someone who's neither affected nor aggrieved isn't even a party. Or we may determine, as was the case here, they're a party. And once we make that determination on the spot, we don't have to deliberate. Once we make that determination, they are cloaked with a new status which they didn't have when they walked in the door.
Let me see if I understand what you're saying. The deliberative process that you're explaining is not recorded. You don't necessarily meet, you don't even have a discussion, but on the spot, somebody presents himself, you consider their bona fides, and on the record you say, you can appear.
Yeah, Madam,
But doesn't that mean that you're making a determination that they are affected?
no, it means that we've made a determination that they may appear before us for whatever reason we so deem. Doesn't have to be affected or aggrieved. And not to be cute with the court, you raise a very serious situation here. In the present case before you, Mr. Stevens appeared, Ms. Durso appeared. On page 16 of the transcript, she says, I'm not sure this fella has standing. on the spot, and I don't mean to be cute, it's the reason they pay me the big bucks at these zoning hearings. I was then confronted by my 5 zoning justices at that time, and they said, Larry, can he become a party? Can he talk? Can he cross-examination? In 3 seconds flat, I said yes.
And that's because he was representing someone who was affected by the ordinance,
Well,
by the variance.
Madam Justice, he could very well have been, but that was not
See,
what was...
I'm trying to help you here, or I'm just trying to, understand maybe for my own purposes. Unless someone makes a determination that the person appearing is affected, you're not fulfilling the terms of the statute that requires that determination that the person is affected by the variance or the application.
Yes, it would be, I think, in 99 out of 100 cases, what you just said is applicable. That is, we should be able to determine if someone's affected. However, that's not what our zoning ordinance says. Our zoning ordinance says that unilaterally, the zoning hearing board may determine who may appear before it, and it doesn't require that there be someone aggrieved or affected.
Maybe your rules and regulations don't comport with the statute.
That could well be. And if this honorable court determines that to be the case, then there's going to be a new protocol throughout the state determining how someone has a status.
Do you have a position on this particular entity as to whether or not it was a person affected by the application?
Yes. I believe that Mr. Stevens' client was affected. I have consistently held that position, and Madam Justice, I'm glad that I did for this reason. Hindsight is 20/20. After I made that decision, and thank goodness the zoning hearing board followed my advice, Mr. Stevens' client was now cloaked at that moment with the authority as a party to proceed. I'm glad I did because, Madam Justice, a year later, when an appeal was taken, Judge Morganelli confirmed in his 20-page opinion that Mr. Stevens' client had party status. Think for a moment, what would have happened if Judge Morganelli had determined that he did not have the status of a party? There would have been a remand back to the zoning hearing board if the judge didn't take new evidence, and we would have been through this process all over again. Rather, what happened was the judge said, yeah, it looks like Fox may have made the right decision. The zoning hearing board agreed that he could be before them, and the judge confirmed that fact. The reason that we're here today is for one sentence found in the Commonwealth Court opinion with which I disagree. The Commonwealth Court stated that a party had to be aggrieved. It didn't say affected. The party had to be aggrieved. And I simply don't agree that that's the law. In fact, my position is not only do you not have to be affected, although in 99 out of 100 times you should be, because we have the right to just proceed unilaterally without that even being a hearing. But the Commonwealth Court stepped way beyond the boundaries of what the law says. They said that you had to be aggrieved. Well, now how are you going to prove that you're aggrieved? Is that going to be a second hearing? Now do we go into a protocol where we have a hearing within a hearing? That's not what the statute requires. And so, respectfully, and forgive me that I'm not talking to all the justices, but Madam Justice, you pinpointed for me what's the core of what's going on here. I respectfully ask you to consider this, and then I'll sit down and be quiet unless you have questions. I believe that Section 275-12E of the zoning ordinance is applicable, and that ordinance reads as follows. Parties to the hearing shall be the township. Any person affected by the application, and my position is could be pro or con, who has made timely appearance of record before the zoning hearing board, and any other person, including civic or community organizations, permitted to appear by the zoning hearing board. That latter phrase, that doesn't modify the entire paragraph. It simply says, if the zoning hearing board determines that you should be permitted to appear, you're a party. Now, that's one of the sections of the statute that's applicable. I respectfully request this honorable court consider as follows. Under section 275, 11F as in Frank, 11, the code says as follows. The zoning hearing board shall have the authority, if they desire, to determine whether a party has standing regarding a particular application. Well, that's the core of my entire argument. We have the authority. We can exercise it any way we want, as long as we're not crazy. I mean, you have to be reasonable on these things. Next, I'd ask this honorable court to consider section 275-12K as in, I don't know what, K, 5, which reads as follows. Nothing in this subsection shall prejudice the right of any party opposing the application to appeal the decision to a court of competent jurisdiction. And so when we got to Judge Morganelli at the Northampton County Court of Common Pleas, I certainly wasn't going to oppose the issue of standing. Mr. Stevens had a right to be there, as he has today. And finally, Justices of the Supreme Court, I'd ask you to consider section 275-12E, which we've already stated was misinterpreted by the Commonwealth Court to believe that there had to be someone aggrieved. That just goes way beyond the realm. Have I spoken enough?
Yes, Mr. Fox, and you've argued it well. I don't know how the case is going to turn out, but I can tell you, you have a very soothing voice.
Thank you so much.
Pleasure to listen to you.
It's great to be here. This is my 50th year practicing, my first time in front of the Supreme Court. It's an honor to be here.
Congratulations.
Thank you.
Thank you, sir. Ms. Durso?
Good morning, Your Honors. I have with me Kendra Eden. She's one of our new associates, just recent graduate of Dickinson Law School, observing the court today.
Welcome. Congratulations. Welcome. Next time you'll be arguing.
Yeah. May it please the court, I am here on behalf of Central PA Equities 30 LLC. We were the applicant before the zoning hearing board. And I think a lot of the argument that is made before is sort of missing the point, being that both the zoning ordinance and the MPC state clearly that the person must be affected by the application. And Mr. Stevens' client was not affected by the relief that was being requested.
You agree there's no requirement that it be aggrieved?
I think it has to be aggrieved for purposes of filing an appeal. I think for purposes of appearing before the zoning hearing, both the township zoning ordinance and the MPC says for purposes of the zoning hearing, you have to show that you're affected by the application in order to participate. There was no showing that his client was affected by the actual relief that was being requested. The relief being requested was limited to variances along a common property line with a Madison Farm development. It has nothing to do with the hotel. The hotel use was permitted by right. It was merely affecting the adjacent property owner who did not appear in opposition to the requested relief. It wasn't regarding a special exception for the hotel. It was purely dimensional variances. And to say that he's affected by the mere fact that they own a competing hotel 1,000 feet away, it's basically trying to prevent another hotel from competing in the area.
Well, let me just probe that a moment, because my understanding is that a hotel could have been constructed without a variance. It just would have been a smaller hotel.
No, the testimony, the area of development allowed was next to, I think it was like a 10% of an area. If you applied the 150-foot setback, the building coverage area for any kind of a structure was limited. It wasn't just to allow for an increase, allow for more rooms. You basically couldn't build much of a hotel at all.
But you could build a hotel, just not the size that your client wanted to build.
It would have been like, it would have been a hotel that would have been a 20 by 20 area or a 30 by 30 area. Like it wouldn't have been able to be a legitimate hotel. because a hotel has to at least be able to have rooms and have an area to go in. So can you build a smaller structure? Yes. Could you actually build a hotel in the footprint that was allowed? No, you would not have been able to build.
Well, but then your point that hotels were allowed in this area is, it's irrelevant, because what your argument is it really, you couldn't really build a hotel there. Doesn't that make their argument that the variance allowed the building of the hotel then in general, not just a larger hotel?
The variance would have been needed regardless of the use, because what happened was the Madison Farm development adjacent to the property was approved with an overlay district. And once it was approved with an overlay district, it allowed the residential component meaning apartments. That then creates now a 150-foot setback for a number of uses, not just a hotel use, from the residential component. So when the township did the overlay, they didn't fix the setback part for that one property that was adjacent to it. So it's not just a hotel. There was a number of uses in the ordinance that would have to be set back that dimension because of there being apartments along that common property line.
Why isn't the appellant impacted just by virtue of the fact that you're building a competing hotel within 2 blocks of their facility?
Well, they are from a business standpoint, but the state of Pennsylvania encourages free enterprise and the ability to compete. And just showing up because they don't want another competing hotel, when the variances aren't impacting them whatsoever, the variances are only impacting the Madison Farm development.
They're impacting it because they're going to build a new hotel. I mean, I get the policy issues, but I mean, the issue that we have before us is whether or not they were affected by this. I don't know how you could suggest that they weren't, being 2 blocks away in being an existing hotel with the variance permitting the building of a new competing hotel. How could they not be affected by that?
But I think if you look at the farmland case, they're saying that it has to be more than just the fact that that use is going to be there to be able to compete. It has to be the nature of the relief being requested. The farmland case says you can't just object to somebody because they're competing businesses.
Yeah, but you've established pretty clearly that without the relief being requested, there could be no hotel.
Yes.
So doesn't that sort of establish the point that the variance is impacting their interest?
Well, but the variance, if you look at the actual variance being requested, though, the variance, yes, a hotel there would impact them regardless of the size or whatever, because it's a competing hotel. But the nature of the relief is not what's impacting them. It's what happens if the relief is granted, which then allows for the hotel. It's not the relief itself, because the relief.
I don't understand that distinction, honestly. Explain that to me.
What I'm saying is that the hotel use is allowed on the property. And if you look at what the variance is dimensional. It related to the setbacks and related to the berm on the common property line. Granting those variances would have an impact on the adjacent property, meaning the Madison Farms, who didn't object to their being not having the buffer and not having the setback.
I understand that, but you've already explained to us that without this variance, there could be no hotel.
Yeah, or very limited, yes.
So, I mean, that's what I'm saying. I mean, the relief being granted affected the appellant.
Let me try to flesh this out a little bit, because I'm beginning to understand where Justice Donahue is coming from. Let me look at this myopically. Is it your argument that the setback and the issue with the berm would be the cause of the aggrievement that must be suffered by opposing counsel? And your argument is that it's not, despite the fact that in a capitalistic society we are permitted competition and free market. They are aggrieved per se in a policy decision by having competition. But your position is that they're not aggrieved because the aggrievement is anything influencing the berm or setback, which only affected the party that didn't object.
Yes.
Okay.
Yes.
So it's a very
You said it much
myopic
better
issue.
than I did.
It's not a policy issue, as I understand this is a conflict of competition, but it's a very myopic issue as to the application of the specific issue of a variance with regard to a berm and setback.
Yes.
Got it.
yes.
Thank you.
But I also, oh,
So under that analytical framework, no one could complain because of an increase in traffic in the area. Because
Cor-
increase in traffic isn't being affected by the 150-foot setback or whatever it is.
yes, I would agree. I would agree. Because that's not what was being proposed. Like, if you were proposing a use, so the use would be allowed. Any use is going to generate traffic. The use is allowed. If you have a special exception, then you could talk about traffic. If you have a conditional use, then you're talking about traffic. If you just have a setback variance, it's not any different than if somebody's building a deck in their backyard and they need a setback variance. And somebody, if you accept their argument, somebody 1,000 feet away who doesn't like that property owner can say, well, I'm in close proximity and I'm affected because I live in close proximity. So I'm going to object to you, to your variance for your setback for your deck.
Except you've pretty clearly explained that without the variance, no hotel would be built. You had a 20 by 20 foot piece of property. We don't call that a hotel where I grew up, anything that would fill that space, and I think you agree with that.
Yeah,
So
yeah.
without this variance, there would not be a hotel.
Well, but it's
There
not
wouldn't
any,
be anything.
but it's not any different than the deck. Without the variance, the deck could not be built.
Just build a smaller deck. You can't build a smaller hotel, which is your rather persuasive argument, I think, given the dimensions that were available without the variance.
Yes, I would agree, because that was the basis for one of the bases for the grant of the variances, yes, yes. But I also believe that the aggrieved status is still required because it is in the MPC in the section that the Justice pointed out earlier. I don't think the aggrieved part of it goes away. Even the Plaxton case that the appellant cited, that first involved an objector who was located across the street, but they still interpreted and did an analysis on the aggrieved status. And the aggrieved status, I would submit, is a even more stringent status than just somebody affected.
Does the term aggrieved currently appear anywhere within the municipal planning code? My
Yeah.
understanding is it previously did appear in 11005 and 11007.
It's in Article 10A,
Okay.
which is the appeals portion of the MPC statute. And the other thing I would say from the aggrieved standpoint is that there wasn't any testimony or evidence to show how they would be aggrieved. And Mr. Attorney Fox is correct. They do, no offense, let anybody come to the hearings and participate in the matters. And our objection was raised at the hearing because we objected that they didn't have standing. They didn't prove they had standing. They didn't present any evidence. They didn't have any witnesses. He didn't even have a representative of the owner accompany him to the hearing. And our argument is the mere fact that he participated and that the zoning hearing board allowed him to participate doesn't then give him the right to file an appeal. Because number one, we objected to it, and number two, he didn't prove that he was aggrieved. You know, he didn't prove that he was affected. And
Being a competitor, in your view, does not elevate to the status of aggrieved.
yes,
Okay.
Okay, thank you.
and the other thing I would say, just in closing, I think it's relevant that many municipalities have a certain radius to which they require notice to be sent, so that a municipality has determined a certain radius of property owners they think would be affected. The appellant's client was clearly outside of that radius. Bethlehem Township established a 400-foot radius. His property was 1,000 feet. So even the township itself, in determining what they thought would be affected, he was outside of that. So they clearly are not affected even under the zoning ordinance standards. Thank you. Thank you.
the issue in this appeal is whether the silver platter or private search exception to the exclusionary rule to the Fourth Amendment applies under the circumstances of this case where the owner but non-occupant of a residence invited police to retrieve firearms, drugs, and drug paraphernalia discovered by the owner during an earlier search of the residence. Please proceed.
Thank you, Your Honor, and good morning, Your Honors. I am Victoria Martin, and I am here on behalf of the appellant, Zachary Capriotti. I believe that the broad issue presented by the court today boils down to two smaller issues, which are very big in effect. One being whether Enrico Capriotti, appellant's father, had the authority to allow Trooper Benjamin to enter and search the appellant's apartment, and two, whether the silver platter doctrine under Boricki in Pennsylvania, or more commonly known as the private search doctrine under Jacobson from the Supreme Court of the United States, is applicable to the search of the appellant's apartment. To begin, I would really like to focus on the silver platter and private search doctrine issue. Your Honor, I believe that the trial court erred in finding that he had no privacy interest, as he was a tenant to the apartment. The surrounding circumstances, given he had total use of that apartment, he was paying the mortgage, the taxes, the insurance. The silver platter doctrine, they relied on that in the sense that when Enrico Capriotti entered the apartment, he found items, and he then subsequently called the police to come retrieve these items. And through that search, he delivered it upon a silver platter, and that's where they...
But if your client has no Fourth Amendment interest in that apartment as found by the trial court, we can't get to that issue.
Your Honor, the trial court, I believe, erred in finding that he had no interest.
And what's the basis of the error? It's
The-
a credibility call, correct? And it would be a credibility, are you saying he erred by not a credibility issue?
Arguably a credibility issue, but I would base it off of the actual factual instances. There was no dispute as to the facts in the suppression hearing as to that appellant was residing there. His items were there. He had 2 weeks left to remain there. He was paying the rents, the taxes, the insurance, all of which equate to a tenancy.
Wait, I apologize. I thought the purpose of his eviction and the auction of the facility was because your client failed to pay for a period of time.
And he may...
Is that true or not?
Yes, that is true, Your Honor. But even so, eviction proceedings had not been initiated at that time frame, and so a tenant still resides in the property until they have fully been evicted.
You say tenant, you mean the son, correct?
Yes, the son, the appellant.
And this isn't a traditional landlord-tenant case.
Correct, Your Honor. There was no written formal agreement, but it was very well agreed upon that there was an oral agreement that if he paid these rents, not rents, but mortgages, insurance, taxes, then he could stay there. And
Which he was in breach of, I mean, if it were a formal arrangement. So what we have here is a father who owns the property allowing his son to stay there under certain conditions,
And
which
his
the son
girlfriend,
did
correct?
not, which the son did not meet.
correct, the son did not meet those. However, that doesn't necessarily preclude him from getting rid of his privacy interest. There is case law.
But counsel, I apologize to cut you short. You still haven't answered the question raised by Justice Mundy and I. Apparently, what I'm perceiving is you're asking us to reevaluate the credibility decision of the trial judge for which is not in our province. So how am I wrong?
I don't believe that it boils down to a credibility issue, Your Honor.
You said arguably it does. So you have to take one position. Either it does or does not. And if it does not, explain to me under what element of law or what element of the statute that was not met or that the judge made an error of law?
Well, Your Honor, if it boiled down to a credibility issue, then the silver platter doctrine wouldn't necessarily be at hand, because then the private search would have applied to somewhere where Mr. Capriotti, being Enrico Capriotti, had the right to be in. Because if he said, "Come on into my home," then it's not really a private search. Whereas it was evaluated as a private search, and there, the private search has to do with somewhere where the appellant would have an expectation of privacy.
But as Justice Mundy indicated, the premise is, how do we even get this case here if the judge made a credibility decision that there was no privacy interest, meaning your client has no standing to assert a privacy interest, which means the father allowed the police into his property and recover weapons, and that's where we are. I'm trying to, can you answer Justice Mundy's question? Because that's an interesting issue that's a premise that you have to overcome.
Your Honor, I believe that
Well, perhaps your position would be that the judge's decision regarding the privacy interest was actually a legal conclusion, not a credibility determination?
yes, Your Honor, I do agree with that statement.
I apologize. Are you adopting the justice's argument as opposed to answering my question?
Your Honor,
It's adopting the justice's argument in answer to your question.
yes, Your Honor.
Uh,
I believe that.
Is that what you're trying to get at? That it was
Yes,
a legal conclusion?
I believe that determining whether or not someone is a tenant and then therefore determining whether or not someone has an expectation of privacy is a question of law, whether or not a question of fact.
The trial court said, at the time and date and place in question, defendant had no vested right, title, interest, or possession of the said premises.
And I believe that he erred as a matter of law in that decision, Your Honor.
That's clearly a legal determination, right?
Yes.
I mean, the fact that the circumstances might or might not have triggered their right to seek eviction is not the same question as whether he had a years-long residency. I mean, you earlier pointed out there had been no judgment from any court of an eviction decree, right?
Yes, Your Honor.
So this is a legal error by the trial court if the judge was wrong. It's not a credibility finding, isn't that right?
Yes, Your Honor. It is a legal error in the fact that he determined that there was no tenancy.
Counsel, I think this is all very interesting. When I read the briefs, I didn't really realize that there was any dispute that he was an occupant. This is very interesting that we're talking about this now, because I didn't really see it in either party's briefs. But I do think that the answer to the questions they very will be in Judge McLaughlin's current accepting memorandum, where she said that the trial judge's finding that he had vacated his premises was not supported by substantial record evidence. Not really, so, credibility is one thing, but you have to have evidence upon which to assess credibility. And she's saying there was no evidence of he was actually not the occupant. In fact, the evidence was the stuff was still there, that he had been there. There was no evidence of abandonment. So to me, it's not credibility. It's either substantial record evidence to support it, and then if so, do the facts support a legal conclusion that he was no longer a tenant or occupant. That I think is, but again, I think this is all very interesting. I didn't read the briefs.
Yes, Your Honor. Again, I do agree with what you stated.
So if it was an error of law, then, was it an error of law that you raised in the aliquotter petition to this court for us to consider whether to grant or deny your petition for aliquotter on an error of law with regard to the possession of the apartment by the parents?
It was an error of law in the sense that
Was it raised in your aliquotter petition?
I believe that the aliquotter petition raised that a landlord had granted the ability to enter an apartment from the police officer, and therefore, yes.
In your aliquotter petition, that the trial judge made an error of law by making the determination that your client had no vested Fourth Amendment rights in that apartment?
Your Honor, without fully reviewing that, I would be happy to follow up with that question.
Well, I have a question. In your aliquotter issue, were you requesting review of whether the Superior Court erred?
Yes. Yes, Your Honor. So the Superior Court really focused on the silver platter doctrine. They didn't go into a lot of detail, but what they did focus on is that there was in fact a private search, and the police officer subsequently followed the steps of that private search. And that is ultimately what we are appealing here. And it does boil down to the facts of the suppression hearing being that...
The Superior Court just made an error in not following the trial court's finding of fact that your client didn't have a privacy interest in the apartment.
Your Honor, that was not wholly addressed by the Superior Court. It was slightly addressed in the the dissenting opinion, where the justice did mention where they thought that the trial court erred in ruling that that search in the apartment was constitutional. They believed that that search by the trooper should not have occurred based off of the silver platter doctrine, because the trooper did himself enter an apartment where, based off of the surrounding circumstances and facts put into the suppression hearing, that he was still a tenant, and therefore entering a tenant's space.
I'm really not trying to give you a hard time, although I have been giving you a hard time. I'm just bothered by the record that bases a premise on a factual record that doesn't support it, and I'm further bothered by the fact that it is not before this court, so I don't see how we as a court are permitted to get to the silver platter doctrine, whether or not it's on a faulty premise, because our preservation rules haven't been followed to give you the opportunity to fault the trial court's record. So I think you understand why.
So we know that's an issue that we'll be looking at. Counsel, could I ask you another question? Did his reasonable expectation of privacy depend at all, or was it influenced by the fact that he was a parolee?
Your Honor, I don't think that it has any bearing on the fact that he was a parolee.
There's nothing in the record about the terms of his parole or allowing searches or anything to that effect, is there?
Correct. No, there's nothing in the record that has to do with the terms of his parole other than that he is, in fact, a parolee. And the search here was not conducted by a paroled officer, nor was it the search done to do with anything as far as the violation of parole. And therefore, even if it had anything to do with his parole, that has nothing to do with his expectation of privacy here.
It could, depending on the terms of a parole.
Probe that.
Yeah.
He's a convicted felon and he's not permitted to have firearms.
Correct.
And his mother indicated she saw a holster.
Correct.
And there was an AK-47 found.
Yes.
And your argument is that he doesn't have a lesser expectation of privacy as being a parolee who has indicated he's violating parole.
He doesn't have a lesser expectation of privacy as it pertains to Trooper Benjamin's search. In that...
But Trooper Benjamin knew he was on parole because the parents told him.
Yes, he did.
So only the officers of the county for which arrested him are subject to search him, or the parolee? Is that your basis?
Your Honor, my understanding from case law is that a search of a parolee is their expectation of privacy and the ability to search without a warrant is when it's done by either a parole officer or when it is done in connection with a direct violation of...
Possession of a gun is in direct violation of a parolee's condition of parole, yes or no?
Likely, however,
Likely or... Okay.
Your Honor, the suppression testimony does not state what is and is not his terms of parole.
And it wasn't the PO going in.
Correct, the PO was
Doesn't
not,
have to be a PO under case law.
But that's the point, that there was no evidence here about a parole search. There was no evidence about any parole officers showing up. So that issue's a red herring in this case, isn't it?
yes, Your Honor.
But you do have evidence that the mother has a gun in her house and she's concerned because her son's on parole, and she calls law enforcement instead of calling probation, I guess. I guess her thought is, I need the cops as opposed to her probation officer, which is making it an equivalent basis for a search.
And Your Honor,
I disagree with my colleague Justice
Yeah,
Swekas.
we definitely have a disagreement with that end of the bench on this case. I'm trying not to answer the questions that they're
You're doing a good job at it, though.
I'm trying not
Although
to
I couldn't
jump in
help
too much.
myself, apparently.
But let me ask you a question, counsel. Is it necessary for us to agree that the private search doctrine shouldn't apply to residences per se to rule in your favor, or are you seeking a lesser ruling?
while here I am seeking a ruling where the private searches should not apply to a private residence, even if you held some kind of less of a bright line rule, I think that just applying a private search insofar as the holding in Jacobson, my client would still succeed, because Jacobson in a private search really focuses on objects rather than places. And what Jacobson really hones in on is whether or not there was a search of a constitutionally protected privacy interest. And there is less of a privacy interest in an object rather than the privacy interest in your own home. And actually, the concurring opinion in Jacobson in footnote 17 even references and anticipates this issue and states that a private search would not apply to a private residence.
Okay, I think we understand your argument. Is there anything you'd like to say in conclusion?
Your Honor, I would just like to submit to the court the potential ramifications of applying the silver platter doctrine in a private search to a private residence and how that could impact tenants and landowners and anyone who may have someone enter into their residence and then subsequently have a warrantless search by a police officer. And for everything else, I will rely on my brief and the brief of amicus for the appellant. Thank you.
Okay, thank you very much. Let's hear from the Commonwealth.
May it please the court, my name is Kenneth Assoc. I represent the Aplt, the Commonwealth of
Mr. Assoc,
Pennsylvania.
would you pull the microphone closer
Sure,
to
Your
you?
Honor.
Thank you so much.
Do you want me to repeat myself, Your Honor?
No, I think we heard the beginning.
Okay. First, the Commonwealth agrees with the trial court that the defendant was not a tenant and had no expectation of privacy in the residence.
Well, that's nice that you're saying that now. That's not what we put in the brief.
Correct.
You argued he had a diminished expectation of privacy because he was on parole. There's nothing in your brief that argues that we should affirm alternative grounds or go to the right for any reason doctrine. In fact, if I read the brief, pages 24 and 25, you can see that the appellant had a bedroom in the apartment. There's no point in time you at all argue he had left. He had no expectation of privacy.
You know, I didn't per se argue the no expectation of privacy. I did indicate in the brief that the defendant was there only with the grace of the landlord. Not the landlord, he was the owner of the property.
You're adopting this new position here at argument today that we should affirm on alternative grounds by saying there is no expectation of privacy, period, based on what the trial court found when you did not raise that in the briefs.
That's correct, because that was not an issue by the appellant either in the case. They did not argue an expectation of privacy in their brief as well, nor did amicus for the Public Defender Association
But I
argue.
think if you're going to invoke the right for any reason doctrine, you have to.
I apologize. I didn't
I
hear.
think if a litigant is going to invoke the right for any reason doctrine, whether it's an appellant or an appellee, it would usually be an appellee, it's your obligation to raise it.
Well, I believe the court has the authority to affirm on any ground, whether raised or not, Your Honor, based on the trial court opinion.
Let me follow up on Justice Brobson's question. Are you now arguing that the fact that he was detained by the somehow constituted an abandonment such that we don't even get to the silver platter doctrine issue?
No, Your Honor, I believe under the circumstances of this case, where the landlord did not the landlord, the owner of the premises did not consider him a tenant, where he was there solely to have a place to stay because of he needed a home plan for his parole conditions, while he was allowed to stay there and had to pay the mortgage. That had nothing to do with his ability to stay at the premises. That had to do with his ability to run the restaurant. The owner of the premises was allowing him to stay there in order to run the restaurant itself and pay all the bills incurred in the building from the running of the restaurant.
So you're going beyond, you are following up again, Justice Robson, where you are perhaps, as a result of some of the questioning here, you are taking a somewhat more aggressive position than your brief took, because you briefed the issues of the private search, Jacobson, silver platter doctrine.
Correct, Your Honor.
And I thought that's where you would be coming from here. Let me ask you, if we were to affirm, in this case, how would that relate to searches of residences in a broader sense, right? Not every defendant is going to be identical to Mr. Capriotti, right? So people have interest in privacy in their residencies, and a lot of people live in apartments, right? Rented apartments, right?
Yes, Your Honor.
So can you explain to us in a situation like this, when somebody's been detained by law enforcement and the premises can be secured, why police can't obtain a warrant before they search the premises?
Well, Your Honor, I don't believe the issue.
We're not only concerned about Mr. Capriotti, we're concerned about the privacy interest of Pennsylvania.
I understand that, Your Honor. While the police could have obtained a warrant in this case, that's not necessary if it falls within an exception. We believe the silver platter doctrine, as well as the U.S. versus Jacobson, as applied by this court in Commonwealth versus Harris and Commonwealth versus Schaefer, permitted the police to do what they did in this particular case. We don't believe that under the circumstances of this case, as opposed to any other case, we're talking about this case in particular, Your Honor, where the police had already been through the apartment in a safety sweep, which was not challenged at all by the defendant in this case. They had a right to conduct a safety sweep of the apartment. They had done so. When they re-entered the apartment at the request of the owner of the apartment who had found the guns, he took them directly to where the guns and the drugs were located in the apartment. The police didn't see anything further than they had already seen through their safety sweep. In the Jacobson case, as well as the Schaefer and the Harris cases, the court indicates clearly that not only must the evidence be brought to the police by a private search, which is not disputed in this case, that there was a private search that discovered the weapons and the drugs in the apartment, but they can't exceed the scope of the private search. In this case, they did not exceed the scope of the private search. They saw nothing in the apartment that they hadn't seen earlier through their safety sweep, other than the guns and the drugs. And under the circumstances of this case, there was exigent circumstances. The owner's grandson lived in the apartment. He was concerned that the grandson could find the drugs and the guns.
Are you suggesting there's a second exception then to the warrant requirement in an exigency argument? I mean, that the children were in the apartment, or children had access to the apartment? Are you relying on the exigency exception in addition to the silver platter doctrine?
That, coupled with the fact that they had not exceeded the scope of the private search, there was an exigency in this case because the grandson was present at the scene. He wasn't in the scene when the police entered the apartment, but he had been present at the scene. The grandfather was concerned for the safety of his grandson. That's why, and he didn't want to touch the guns and drugs, which is understandable. Number one, he couldn't legally touch the drugs and bring them out to the police. He didn't want to touch the guns, as was witnessed by the earlier search of the restaurant in which the AR was found in that earlier search. So yes, there was an exigency, as well as the fact that the police did not exceed the scope. Their actions did not exceed the scope of the private search. They saw nothing. And I think that's the concern.
No.
I'm sorry, Your Honor.
I gotta get used to this button thing. What was the exigency with the grandchild?
The grandson was present at the scene, Your Honor.
But what was the grandchild living with the grandparents?
The grandchild, no, the grandchild was living with the father.
But as I understand the trial court's finding, the father had abandoned, at least what I've heard today, had abandoned. So there was no risk the grandchild was going to go back into the room. I'm assuming he was with the father.
Well, all his items were still present in the room, in the apartment. as
But
well.
if the father had abandoned, and
Yes, I apologize, Your Honor. The grandson had items in the apartment that he would have obtained. He would have gone back into the apartment to obtain his items. Nor had the grandfather,
how old was the grandchild?
14.
And so the grandchild was still living there and had access to it, even though the father, according to the trial court, had left and abandoned it?
Well, I believe the wife as well had the access to the apartment as well.
So even though they had abandoned, they had access.
The father had it, yes, Your Honor.
Okay.
Aren't we, I thought we were not looking at this case as an exigency claim. I thought we were inquiring about the silver platter doctrine, isn't that right?
The silver platter coupled with the Jacobson case.
Okay, let me ask you about Jacobson. I thought Jacobson and Schaefer made it pretty clear that the silver platter doctrine we look at relates to objects, whereas this case is about a home. Isn't that right?
It was the objects in the home, the guns and the drugs. Police conducted no search of the home. They simply seized what the private citizen had told them, had taken them to the location where the guns and the drugs were at.
I guess what I meant is, I appreciate that. I guess what I meant is that analytically, Jacobson was the torn package at FedEx and Schaefer was the computer with the technician. Those cases did not involve an asserted privacy interest, which brings different constitutional questions for us. Would you agree with that?
It does, slightly it does, Your Honor. Again, under Jacobson, it's broad under Jacobson as well as under Harris and Schaefer, that again, as long as the police do not exceed, their actions do not exceed the scope of the private search, it's constitutional.
And on that search scope issue, my understanding, and please correct me if I'm wrong, is that on that first protective sweep through the apartment, that Trooper Benjamin did not reach the closet, but that then in the later visit at Enrico's invitation, Trooper Benjamin went into the closet. Did that not expand the scope?
I don't believe so, Your Honor. He didn't enter the closet in the first safety sweep. That doesn't mean he didn't see with the contents of what was in there, other than the guns and drugs, which are at above eye level on a shelf, and he was not conducting a search, according to his testimony. So no, I don't believe it exceeded the scope of the prior search, not search, but the sweep by the police in this particular case.
But that's not the analytical framework for a private search. I mean, the private search is a search conducted by the private individual, not the prior sweep done by the police officer, which was ineffectual. The search we're talking about is a search that the father conducted of the home.
Correct, Your Honor. Which was not at issue in this case. The appellant is not contending that the search by the father was unconstitutional or illegal. They're not contending that the father couldn't, had he wanted to, brought the guns and the drugs out to the police and given the police the guns and the drugs. Obviously, he would have broken the law had he done so, because he would not be in illegal possession of the drugs. But the sweep is important because, again, under the Jacobson case and under the Schaefer and Harris cases, it's the scope. The police can't exceed the scope of the private search. In this case, they did not exceed the scope.
Their sweep was not a private search.
No, their sweep was not a private search, but their sweep is not contested, that they'd already seen the contents of the apartment, absent with the exception of opening drawers and other things, and the observation of the guns and the drugs. Excuse me. observation of the guns and the drugs in the
What we're
closet.
concerned about here is the private search that was conducted by the father.
Well, the private search was clearly lawful. That's not an issue. The private search by the father. The issue is whether the police entry into the apartment and seizing the guns and the drugs was lawful. And under the Jacobson case, again, because they did not exceed the scope of the private search, they saw nothing other than they had already seen,
Except for seizing the guns,
except the guns and seizing, yes.
which exceeded the scope of what the private citizen did.
I'm sorry, Your Honor.
Which exceeded the scope of what the private citizen did.
No, it didn't exceed the scope of what the private citizen did. They simply took the guns and the drugs that the private citizen had observed and told them and directed them to the guns and the drugs. They didn't exceed any scope of that search by the private
And
citizen.
ask them to take, right?
He asked them to take it. He didn't want to take it.
Okay, I think we understand the case. Do any of the justices have any further questions? All right, do you want to wrap up? Do you have anything in conclusion?
No, Your Honor, I rely on the brief of
All right.
my
Thank
brief
you,
as well
sir.
as
Thank
amicus
you, sir.
briefs. Thank you, Your Honor.
Commonwealth of Pennsylvania versus Nazir Taylor, representing the Commonwealth, Mr. Todd Barnes, representing Mr. Taylor, Ms. Rachel Silver.
Good morning. This case involves a prosecution against Aplt for offenses committed when he was a juvenile. The case was transferred from juvenile court to adult criminal court based in part on appellee's refusal to admit his culpability. Admissions the juvenile court concluded were necessary in order for appellee to show his amenability to treatment in the juvenile system. Appellee was convicted in criminal court, and on appeal, we found the juvenile court erred because we concluded that by considering appellee's refusal to admit guilt in transferring the case, the lower court violated appellee's right against self-incrimination protected by the Fifth Amendment to the United States Constitution. Following a remand to the Superior Court, we are now asked to address whether the juvenile court's error in relying on appellee's refusal to admit guilt can be considered harmless in light of the other evidence supporting the juvenile court's transfer decision. If not, we are further asked to address what remedy appellee is entitled to, given that the juvenile court now lacks jurisdiction over him. Please proceed.
Good morning. May it please the court. Todd Barnes, Montgomery County District Attorney's Office, on behalf of the entire Commonwealth of Pennsylvania. So first of all, thank you for granting our petition for allowance of appeal. I spent a good deal of time drafting reports recommending that aliquotter be denied, and so I certainly appreciate the opportunity to bring these issues before you. I know this court is very familiar with the facts, and I want to begin by highlighting what I think is a critical contextual point. The Commonwealth established three things at Part 1 of the certification hearing, certification proceedings, which are not in dispute. Number one, that Mr. Taylor was over 15 years old at the time of his offenses. Number two, that he was previously adjudicated for a felony. And number three, that there was a prima facie case that at that time that he had raped a significantly younger child and subjected him to IDSI. The establishment of those three items during Part 1 of the certification process is not in dispute, and as a result, the Juvenile Act placed the burden squarely on Mr. Taylor, then 17 and a half years old, to prove that his case should not have been certified. That begins to set the context for the error that we're talking about, and since a jury later found this defendant guilty of this series of rapes and sexual assaults on a middle school aged child, all of it brings us to what I think is one of Justice Brobson's favorite questions and mine as well. How do we do justice in this case? I'm asking this court to remand to the Court of Common Pleas for reconsideration of the 2014 certification order, nunc pro tunc. Now, we're here today because the Superior Court effectively said, sorry, but regardless of what happened to that little boy, we can't do justice in this case because the Court of Common Pleas supposedly doesn't have jurisdiction. That's not acceptable in the Commonwealth of Pennsylvania, and it's particularly unacceptable when the Pennsylvania Constitution and the General Assembly say that the Courts of Common Pleas have unlimited original jurisdiction in all cases, actions, and proceedings where jurisdiction is not vested in some other court. There has to be some jurisdiction somewhere because the Constitution says so, because the governing statute says so, and because we're supposed to do justice, since that's the whole point of having a judicial system in the first place. Yes, Your Honor.
Pardon me, counsel. What would be the purpose of a remand? We can't have a certification hearing. The ostensible benefits of the juvenile system would not be available in any case. Wouldn't the whole thing be an empty gesture?
I don't think so, Your Honor. Again, the purpose would be for a reconsideration of the certification decision, nunc pro tunc. Similar to if you were to get to, and I don't know that you will, but if you were to get to a harmless error analysis today, it is the same thing. It is looking, although applying a different standard, but looking after the fact at a decision that was made in 2014 and determining whether the record supports the order that transferred.
Suppose the court finds that it did not. Suppose it's remanded, it goes back to the Court of Common Pleas, no particular division, and the new judge says, case is not certified to the adult division.
Easy, discharge.
Well, it's not discharged, because discharge is only a remedy that exists under the Juvenile Act, right? There's nothing outside of the Juvenile Act that talks about discharge.
Well, I mean, the reality is, if you send this case back,
right,
and the trial judge or juvenile division judge looks at the order and says, this order is not supported by the record, then there's no basis.
Well, then you vacate the conviction.
Correct.
That's not discharge. Discharge is something that exists in the juvenile system, and we cannot go back to the juvenile system. So discharge can't be, if the criminal court doesn't have the authority to make the certification decision, then the criminal court doesn't have the authority to grant a discharge.
So Justice Brobson.
So the best that could happen is it goes back, a criminal judge, perhaps the trying judge, if that judge is still there, engages in a certification type of analysis to determine whether the case was certifiable, and if it wasn't certifiable, then the conviction is vacated. Or if it was certifiable, then the conviction stands.
Justice Brobson, you and I have no disagreement in terms of the analysis there. Whether we use the word discharge or vacate the conviction, it doesn't personally make me any difference. We're saying the same thing using different words, in my opinion. So again, the whole point of having a judicial system in the first place is to do justice. It's the reason that this court exists. It's the mandate given to all prosecutors, and I think the real question is, how do we get there from here? The constitutional error in this case was not an error in establishing the facts at trial. I know we have to talk about the harmless error doctrine at some point, but I want to be clear that I'm asking this court to send the case back to Common Pleas for a proper reconsideration so that we can eliminate the error altogether and leave no doubt about the legitimacy of this judgment of sentence. So with that said, I want to begin with my argument on jurisdiction and then move to harmless error in due course. The law on jurisdiction here, as we know, there's certain things that are not in dispute, right? The Pennsylvania Constitution, Article 5, Section 5 says there's only one court of common pleas in each judicial district having unlimited original jurisdiction in all cases, except as may be otherwise provided by law. And we know that the General Assembly provided Section 931 of the Judicial Code as the very first subsection of Subchapter C of the Code. Subchapter C is entitled Jurisdiction of the Courts of Common Pleas, and Section 931 is entitled Original Jurisdiction and Venue. It says, except where exclusive jurisdiction of an action or proceeding is vested in another court of this Commonwealth, the courts of common pleas shall have unlimited original jurisdiction in all actions and proceedings. So that has to be our starting point for discussing original jurisdiction in the courts of common pleas. And if we stop there, there isn't a single case, a single Pennsylvania case that can escape the reach of our judicial system, because if jurisdiction is not vested in another court of this Commonwealth, these provisions say that the courts of common pleas have jurisdiction.
But counsel, it's up to the legislators to determine which court has jurisdiction. That's within their power, not ours. So why are you not before the legislators requesting a fix to this loophole?
There's absolutely no need to be before the legislators, and that is the point that I'm trying to emphasize here. There is no loophole. There is no fix that needs to be requested. The legislators already provided Section 931 that says if there's not jurisdiction in another court, if the General Assembly hasn't vested jurisdiction in another court, then it rests in the Court of Common Pleas. Chief Justice Baer once used the phrase jurisdiction by default, and I think that's exactly what we have here. The Courts of Common Pleas have original jurisdiction by default, according to...
If I understand you correctly, an individual, a juvenile, that was brought on a certification petition was deemed incorrectly a factor, the child's silence was deemed an important factor by the judge, which is in error of the existing case law and his child's constitutional rights. And yet during this time period, he ages out of the juvenile justice system, for which had he not been certified, he would have enjoyed rehabilitation, treatment, and supervision for 4 years in placement or until he turns 21, whichever came first. Now he's subject to years of potential incarceration. So you say that the Constitution, and he deserves a trial, and jurisdiction should fall in the Court of Common Pleas. Is it your position before this court that the juvenile court is analogous to adult court, such that a child or an act committed as subject to certification should now, because of an error of a judge, endure the penal system as opposed to the rehabilitation system, yet knowing we're precluded from rehabilitation strictly by age? I'm trying to gather what you're asking us to do, to say that if judges make incorrect decisions and it affects juveniles, then they forfeit any opportunity to the juvenile system, and we strictly ship them off to adult court for jail. Is that what you're asking us? Because that's what it sounds like. I just want to be honest.
All right, so short answer to your question, Justice Doherty, is no. That's not my argument. And to be honest, I'm having a little bit of a difficult time following the entirety of your question, but I think where the disconnect is I'm not saying that the certification judge made the wrong decision in certifying this juvenile to be tried as an adult. Now please send it back. I'm saying the certification judge made the right decision in certifying this juvenile to be tried as an adult. That would get us more into the harmless error conversation, and then beyond harmless error, it's sending the case back to the Court of Common Pleas to have them reevaluate. But ultimately, I'm asking for a judicial decision that says whether or not this certification order was proper in spite of the fact that the judge made an error in his analysis.
You said we were discussing jurisdiction.
Yes, I'm
Harmless
trying
error-
to.
You've just given me a harmless error argument. I'm still inquiring as to I don't understand how you come to the conclusion jurisdiction is in the Court of Common Pleas as opposed to, at one point, it could have been a juvenile court, and this is not an error created by us, it's an error created by, a loophole created by the legislators when they passed the Certification Act. So explain your jurisdictional argument. Leave out the harmless error.
Harmless error aside, honestly, I think my jurisdiction argument is relatively simple in terms of focusing on the Constitution and Section 931, right? The Pennsylvania Constitution says, Court of Common Pleas, unlimited original jurisdiction in all cases. That's simple and straightforward, except as otherwise provided by law. So the next step is, well, let's look at what laws have been provided that modify that grant, constitutional grant of unlimited original jurisdiction.
Can I follow up on Justice Dougherty's question then? Because the,
Justice Wecht, would you allow him to answer?
oh, I thought you had come to a pause. I misunderstood.
I probably did pause. I don't know if Justice Dougherty is looking at me like he's not at all satisfied
But
by
I'd
my
like
answer.
you to finish your answer, yes.
I guess the question, go ahead, but my follow-up would be, so what you're saying is that there should be no juvenile branch in
No.
any of the, that's what my problem is right now, what you're saying is, because our Constitution permits the Court of Common Pleas with all, you know,
Let him finish.
So
maybe
if I
we'll
may,
get that answer, yes.
if I may, listen, I love the fact that we have a separate juvenile division. It's necessary. And I appreciate all the work that you did for my hometown in Philadelphia, serving in the juvenile courts. So I am not at all advocating.
Right, you know where I'm coming
like some people have advocated to abolish the juvenile justice system. I'm not saying that at all. What I am saying is, if we come to the point like where we are now, where you're saying the juvenile division can't do anything, then what you're left with is not, oh, there's no jurisdiction anywhere. What you're left with is you're back to the default jurisdiction of the whole Court of Common Pleas, which the juvenile division is part of, but the juvenile division exercises the jurisdiction of the Court of Common Pleas, which exercises the jurisdiction of the Commonwealth of Pennsylvania.
So what happens next?
So what happens next? I think there's a couple of ways to go about it. My recommendation would be you send it back to the Superior Court, to send it back to Common Pleas, and you let the Court of Common Pleas work it out in the sound exercise of discretion. So that case then goes back to Judge Carpenter as the trial judge. If the defendant insists on a ruling from a juvenile court judge, we can get findings of fact and conclusions of law from Judge Smith or any other juvenile court judge. Like the specific judge who makes the determination doesn't make me any difference. They're exercising jurisdiction on behalf of the whole Court of Common Pleas, but again, it's reviewing what's already taken place in 2014, reconsideration to determine whether this was the right result in 2014. And in order to get to that place, you have to leave out the constitutional error, the fact that they considered that this young man wouldn't own up to what he did.
Okay,
You
we have,
answered my question.
we have some.
Thank you for your question.
We have some follow-up questions. Justice Wecht and then Justice Donahue.
Yeah, I wanted to follow up on Justice Dougherty's questions. The General Assembly here could expand the juvenile court's authority to hold these certifications till 21, like some states have done, right? They could do that, right?
I don't see why they couldn't.
But we don't have that, and so that's why I was prompted to ask this question, because suppose we gave you some kind of relief and it went back down. Wouldn't this hearing be a completely empty gesture? In other words, the whole idea of these certification hearings, because like Justice Dougherty, I served in juvenile as well, is to afford the opportunity to try to explain why the benefits of the juvenile system should be available to a particular defendant, right? That's not on the menu here. In other words, that's never going to be an option for this particular fellow, right? I mean, that's so. There's.
No, I don't agree
The
with
point is,
that.
it would be a sham. With nobody's bad intentions. The reality would be that such a hearing on remand would be an absolute empty gesture. Do you follow me?
I do.
Do you agree or not agree?
I do follow you. I do not agree with the premise that this young man will never have the opportunity to make his record that his case shouldn't be certified. He already had that opportunity. He already made his record. And so even in asking for a remand, I'm not asking for a new certification hearing. I'm asking for the court to be able to look at the record from the prior hearing and do a reassessment without considering a factor that
I thought you were asking for a certification hearing.
I'm asking for a reconsideration of the certification order, nunc pro tunc. That is what I'm asking for. And I know, Justice Donahue, I know you have a question. You've been trying to get to. I probably talk too much, but just so I'm clear, the reconsideration analysis that I'm asking for, it doesn't require a new hearing. But if either party wanted to make a motion in the Court of Common Pleas to reopen the record for whatever reason, then the Court of Common Pleas, a judge could consider that. I'm certain we wouldn't make a motion to reopen the record, but if the defendant wanted to make that motion, then the judge has discretion to determine whether that is the right course of action.
Okay, Justice Donahue.
You
Sorry.
want us to totally ignore the fact that the Juvenile Act does not apply to this individual. Period. Forget about jurisdiction, forget about which court has jurisdiction, forget about open jurisdiction, forget about all of that. This gentleman is not amenable to having the Juvenile Act apply to him. Period. He's aged out. You can't send a case back to any judge and pretend he's still a juvenile, which is what this remedy asks us to do. Pretend he's still a juvenile, pretend this certification proceeding is taking place in the context of somebody who is actually amenable to a Juvenile Act proceeding, and take it from there. That's the problem. That's what the jurisdiction is a strange word in my mind to try to shoehorn the problem that we have here. This young man is no longer amenable to having anything to do with the Juvenile Act. It's over. It's just over. So, it's not a court of common pleas question, it's a fiction. It's a fiction that you're suggesting we should engage in here by sending it back to another judge to reconduct, re-review a certification proceeding that can only take place in the context of a case where you have a juvenile at issue.
So I understand your point. I understand your question. I don't agree with it.
What don't you agree with?
Respectfully.
That he is a juvenile?
I'm sorry?
He's not a juvenile.
What I don't agree with is that what I'm asking the court for is to engage in some sort of fiction. Under the Juvenile Act, when this defendant was a juvenile, he was entitled to a certification hearing. He got one. And all I'm asking for is a re-examination or a reassessment of that record from 2014. Again, I keep using the phrase nunc pro tunc. It's the same way that you would do the analysis, although it's from a different angle if we were doing a different standard, if we were doing harmless error. Harmless error analysis, to ask you all to do a harmless error assessment right now, I'm not asking you to engage in a fiction because the hearing happened in 2014. You're applying a legal standard to a set of facts. And that's what I'm talking about with reconsideration. I'm sorry I keep going back to the harmless error, but that's what I'm asking for with reconsideration. Apply the legal standard to a set of facts and a record that was established when the Juvenile Act was fully applicable.
Have we ever done that when a juvenile's aged out? I mean,
I think that's why we're here.
Have we ever done that, though? Can you cite a case
No.
where we've ever done that for somebody who's aged out?
I cannot cite a case. I think that's why this issue is here as a matter of first impression.
And then what happened to the rehabilitation and treatment to which he would have been entitled if a certification hearing had taken place and the case is not transferred? He just never gets the benefit of the Juvenile Act.
That is correct, and I don't think there's anything that we can do about that.
Well, but see, that's the problem with it's not even a half-hearted attempt to apply the Juvenile Act because, as I see it, the Juvenile Act is out of this particular individual's bailiwick. He's too old. He's too old. So we're just faced with a defendant who's aged out of the system. And there's a gap in the statute that allows this to happen.
So I just don't see the gap in all cases, all actions, all proceedings. Unlimited, I mean, those are really broad, sweeping terms. And so I totally understand your point, and I think I agree with it. If we get to the point that a judge on reconsideration says he should have never been certified, right? Then, I mean, there's a tragedy that has taken place that we can't undo. If, on the other hand, the judge on reconsideration looks at the case and says, you know what, there's 7 factors that we were supposed to look at to determine whether this young man should be certified, and this defendant didn't bother to address at least 5 of those 7 factors.
Was there live testimony in the original certification proceeding?
Yes.
We're not going to have that here on your
Correct.
hearing. You're going to have somebody take a look at a cold record. I mean,
Correct.
It's a fiction upon a fiction. I mean, it's not a new shot at certification, and a certification cannot take place now because he's too old.
All we can do, Your Honor, is the best that we can do. If we get this case back to Judge Smith, then he was there for the live testimony. And so that eliminates that aspect of it. But there is that difficulty, Your Honor.
Mr. Barnes, do you want to address the harmless error versus structural error question?
I think I do, Your Honor. So I'll take it that the court is signaling me to move on from my jurisdiction.
Well, unless
Argument.
the justices had any further questions on that subject.
So I'll just note then, before moving to harmless error, that the defendant in this case makes 4 key concessions. In his brief that I like to highlight, the defendant concedes that the Pennsylvania Constitution and corresponding statutes give the Court of Common Pleas of Montgomery County jurisdiction in this matter. That's in his brief at page 41. 2, he concedes that the courts of common pleas have unlimited original jurisdiction, and 3, he concedes that remand is the appropriate remedy where there's a problem with a certification decision. And 4, he concedes that this case should be remanded at page 53 of his brief. So we agree on those major points. The one point that we disagree on is he says there's no place to send the case back to. And of course, we've been over it, but again, I feel like I keep ringing this bell because I like the way it sounds. Unlimited jurisdiction in all cases.
Since you're ringing the bell again, let me just ask it a different way. Following up on the question, is it truly call it what you will, a cold record, a recertification, a hearing, or whatever? Is it in any sense a real proceeding when he cannot possibly win, in quotes? You know, there's no way it's such a proceeding. He cannot possibly win, right? He's aged out in the meantime, and you want it to come back to somewhere in the common pleas court. And it's such proceeding. He can't possibly win that. So how is that a proceeding at all?
Mm-hmm. So the best case scenario for him at this stage, as Justice Probson corrected me on, is an order vacating his judgment of sentence, right? And that is, do you call that a win? Well, I mean, he's still incarcerated now. He would be on parole after, at some point after his minimum, and then I think there was another 10 years of supervision. So for him, that would be a win. For the citizens of this Commonwealth, that wouldn't be a win because there's no question about what he did. Like the fact that he committed this series of horrible crimes, like that, you can't erase that. That is what's been determined by the jury, and if he's discharged now, we don't know who is being discharged or who may be in harm's way, and that
The bunny in the hat. You just put the bunny in the hat. That's why he can't win. That's why he can't win. I mean, had this case not been certified, he may have gone through rehabilitation and treatment and followed the protocols of the Juvenile Act, and we'd have a citizen out there who may be rehabilitated. That can never happen now.
So,
I mean, you just prefaced your whole argument with the fact this has to go back because he committed these heinous crimes and he's been convicted by a jury of those crimes. How do you undo that?
You can't undo it. And it's not my argument that you can undo it. My argument is that we don't need to undo it, and it shouldn't be undone because the certification hearing record fully supports the certification order.
Can I ask you a totally unrelated but maybe directly related question? Why was the Superior Court incorrect when it found that this was structural error? That was not susceptible to a harmless error analysis.
Why? Okay, so we're moving on to our harmless error.
No, we're moving on to structural error. We aren't moving on to harmless error. If there was structural error, it's not susceptible to a harmless error analysis.
Right, but it's the same general subject in our aliquot or grant. Was it structural error or was it harmless error? Okay.
So, if your conclusion is that the only possible avenue for doing justice in this case is harmless error, then that is the argument that we make. But in making this argument, I do want to briefly acknowledge some of the amicus briefing that we received from groups that, as I stated, some of them say they want to abolish the juvenile justice system altogether. I'm not sure how you do that, but they cited some troubling racial disparities in criminal justice, and I do want to say that I think that those are important policy issues that the General Assembly should look at. And so I understand that the topic of trying juveniles as adults is a sensitive issue in the first place. And I want to try to choose my words carefully because of that. But really, like, what is anybody supposed to do with a 17-year-old who repeatedly raped a much younger child, a middle school student, and how do you prevent him from doing it again in the future?
Could I just jump in
that
there? I mean, I think the obvious answer is that hopefully going forward, courts won't make the same error that was made in Taylor 1. I mean, I don't think there's anybody here on the bench that would blithely respond to your rhetorical question by saying, you know, we don't care about those crimes. The fact is that you can't do what happened in Taylor 1, and then these prosecutions can go forward.
Right.
Yeah.
And there's no
Clear in JB as well.
Yeah, and so there's no dispute about that, and I don't mean to suggest anything different than that, but in the courts and in law enforcement, the best that we can do is make every effort to apply the law fairly. So ultimately, my argument is that the harmless error doctrine is applicable in cases like this, and the error in this case was non-prejudicial, because regardless of the error during the certification hearing, and there was an error, we're not here to dispute that over again, but this defendant clearly failed to meet his burden under the law to prove that his case should have been retained in the juvenile justice system. As a general rule, harmless error is available to uphold a judgment of sentence when we can show beyond a reasonable doubt that the error was non-prejudicial. You know, when we talk about whether that doctrine applies here, I think really a starting point for that analysis is looking at interest of JMG, because that's the case that the Superior Court seemed to rely most on. So JMG's analysis started by quoting United States versus Chapman, a U.S. Supreme Court case, to note that there are some constitutional rights that are so basic to a fair trial that their infraction can never be considered harmless error. And Chapman outlined a list of examples where a person is forced to confess and that confession is used against them at trial. That error can never be harmless. Where a defendant is denied the right to counsel, that can never be harmless. Where a defendant is denied the right to an impartial judge, that error can never be harmless. That makes sense. And in JMG, we added another case to that list, and it's not an exhaustive list, but violations of the psychotherapist's patient privilege in commitment proceedings. You can't violate the privilege and then use the words that are supposed to be shielded by that privilege to incarcerate somebody.
Lawrence, can I just ask, though, if you look at the trial, the certification judge's decision in this case, it seems relatively obvious that this no admission of guilt was virtually the exclusive basis on which the trial judge, or the certification judge, chose to certify this to the criminal division.
I'm not sure why you say that, Your Honor.
Because as I read the analysis, it was pretty much focused. I mean, sure, he went over the evidence, but the analysis was focused on the non-admission of guilt. At least that's my reading. If you want to point me to some other part where the certification judge analyzed all of the other factors, but you know, it seems he was emphasizing the age of the juvenile at the time and how the first step to recovery and rehabilitation is an admission of liability, and it seemed to all be intertwined in there. And you know, sometimes when you have a jury verdict and there's all this evidence, overwhelming, uncontradicted evidence, you could be in a circumstance where you have to guess what the jury would do. Here we don't have to guess. The judge basically said it. And I'm afraid that if we try to conduct an analysis of this judge's decision like we would, say, a silent jury verdict, you're essentially asking us to reevaluate the evidence as if we were certifying the case, when it seems to be clear that the judge really did rely on this evidence, and it's not at all clear to me that the judge would have reached the same decision if he had disregarded it.
So I certainly understand your point, Justice Brobson. I don't agree that the
That's
judges
okay, by the way.
but you know, to your point, I don't agree that the judge relied exclusively on the fact that this juvenile would not admit what he did. Really, so the conversation about amenability, what the trial judge wrote, what the certifying judge said about amenability, that came out of the evidence that was presented and the argument that took place at the certification hearing, which frankly did not, other than the Commonwealth saying, look at all these factors, they all obviously weigh in favor of certification. Those points were not in dispute because the defendant didn't argue on any of those first five factors.
Oh, so this is interesting. So you're saying that the only reason the certification judge addressed amenability so hard is because that was the only element of evidence that was presented by the party at the time.
That was the issue that was primarily disputed. However, and I would refer, Your Honor, back to the trial court's opinion and the certifying judges. I think he gave his reasons on the record, but it's in Judge Carpenter's 1925 opinion. He specifically mentions the remaining factors. Again, doesn't go into great detail. There was no need to, because those things weren't in dispute. They aren't in dispute now, and because the first 5 of 7 factors aren't in dispute, because the defendant didn't even really try to address those factors, I think it's clear that on this record, this particular certification order is supported by the record. I mean, I don't know where you can go in and skip 5 out of 7 statutory factors and say, I've met my burden of proof.
Counsel, but that's not the question when we're asked to conduct a harmless error analysis. The question that we have to ask is whether his refusal to admit guilt in any way impacted the certification decision. Justice Brobson was pointing out, not only was it any factor, at least as to what he wrote about, it was the primary reason that he certified the case. So, I mean, in a harmless error analysis, I mean, we're stuck with what the trial court said.
Right, so
I'm
think...
certifying this because he won't admit guilt.
So I would just invite and ask Your Honor to go back and look at the trial court's opinion. I'm pretty certain that the trial court didn't say this is the primary reason for this certification. I think that the trial court did what it was supposed to do. The certifying judge did what he was supposed to do.
But the question is, could have his refusal to admit guilt have impacted the certification decision?
Well, it did.
The answer is, of course it did.
It did. No, there's no dispute about that.
It's not harmless.
My argument on harmless error, to be more specific, is that when you look at the whole of the record, when you look at it in context, when you consider the fact that this juvenile had the burden of proving that his case should be retained in the juvenile justice system, and he skipped 5 of the 7 statutory factors, I think it's beyond a reasonable doubt that this case would have been certified. Once the Commonwealth establishes a prima facie case under the statutes, presumptively this case should be certified. That's why the burden of proof then shifts to the defendant. So it's his burden to then prove that his case should be retained in the juvenile justice system. We've got 7 statutory factors, mandatory statutory factors, and he skips the first 5. So my argument for non-prejudicial error is based on that.
All right, are there any more questions from the justices? All right, thank you very much. Well done.
Thank you.
All right, Ms. Silver?
fine. Good morning. Still morning? Yes. Good morning. May it please the court, my name is Rachel Silver. I represent Nazir Taylor, the appellee in this matter. Before I proceed with the arguments already presented to the court via brief, I want to emphasize that the thorny issues of whether this is structural error, which it is, or whether remand is legally allowed, which it isn't because of the expiration of the juvenile court's jurisdiction, all of that can be avoided by simply deciding that the underlying constitutional error in this case was so obviously harmful and prejudicial that no remand is necessary to decide those issues. As the concurrence that was authored by the late Chief Justice Baer and joined by Justices Donahue and Dougherty in the 2020 decision stated, the prejudicial error in this case plainly resulted in Taylor being certified to the adult court. This was agreed upon by the Superior Court, which declined to review the matter again en banc because the questions that were posed by this court were answered so clearly that the underlying constitutional violation has a harmful and prejudicial effect, is an error that is so great that Taylor should be, and I believe the Superior Court said discharged, but also have sentence vacated. This honorable court could similarly decide that the error was harmful and resulted in an erroneous certification, thus requiring reversal and for a sentence to be vacated. It would not require the court to answer the structural versus trial error question, the harmless error question, or the jurisdictional remand question, and would be appropriate because, as the justices have pointed out, the record is cold. It is the same record that would go to the Court of Common Pleas or any lower court if this were remanded to reach the same conclusion. So because no remand is necessary under any analysis, really the court doesn't need to go forward.
Silver, I tried to follow your argument. Your first argument focused on structural error, that it was structural error. What was the premise for your second argument?
Well, the second piece that, again, I don't think that the court even needs to get to is that the juvenile court no longer has jurisdiction because Mr. Taylor has aged out of it.
Okay.
What I'm saying is that remand really isn't necessary because the court can decide based on the nature of the error that it is harmful and prejudicial that reversal is necessary.
Counsel, can I just ask you a question? So there's a lot of discussion and questions to Mr. Barnes about, we talked about the remedy and the fact that the Juvenile Act isn't even available anymore because your client aged out, which I think we all agree your client aged out. And as a result, the Juvenile Act does not apply anymore, and therefore he can't get a new certification hearing and all those things. Why doesn't that also cut against you? In the sense that because your client has aged out, this whole issue about whether the certification hearing was proper or improper is now moot. Because he doesn't have any rights under the Juvenile Act anymore. He's aged out. So the case is basically moot. It's not dissimilar to circumstances where someone is challenging a revocation of parole and they get released in the meantime on probation. The parole revocation becomes a moot question. So why isn't this case moot? Because your client no longer has the protections of the Juvenile Act.
Respectfully, we shouldn't be comfortable with the idea that juvenile defendants are not due proper recourse when their constitutional rights are violated solely because of the passage of time during an appeal period that has seen them grow to the age of majority.
I completely agree with you. I guess the question, though, is, that goes back to the question of remedy. And that, to me, is the hardest part in this case. The remedy that you want, I think, is a remedy that would have been available to your client if the client had succeeded in fighting the certification to criminal court and ultimately was discharged from supervision under the Juvenile Act. The remedy that the Commonwealth seems to be arguing is, well, we can't put all the toothpaste back into the tube, we can't send you back to juvenile court, but at least we can go back and have a hearing. I'm not sure I agree with Mr. Barnes that it has to be a cold record hearing, but we can at least go back to the criminal court and have the criminal court have a hearing on its jurisdiction and whether it properly exercised jurisdiction in this case in light of the Fifth Amendment violation. What's wrong with that? It is a remedy. What's wrong with that one?
Well, what's wrong with that is that the adult court never should have had the jurisdiction. You know, if we kind of make the leap there.
Yeah, and I apologize for interrupting. That may be true, but the Juvenile Act does say, does it not, that once the transfer order is made, the Juvenile Act no longer applies.
But in this case, the transfer was erroneously made.
I agree, but the Juvenile Act does not address a remedy for an erroneously made transfer.
That's correct, and I think that's one of the issues that the court and Mr. Barnes has struggled with. The option there is then for the legislature to step in and create an answer, that there is a very glaring gap that exists here, but that Mr. Taylor shouldn't be the one to suffer for the gap. The legislature can step in and come up with any number of possible remedies. The safety valve from Kent or from Black is available. Juvenile.
The fact that the decision of the court to transfer or to not transfer is interlocutory, so that an appeal could be taken on that issue prior to a post-trial direct appeal. And in this case, you knew, or whoever was representing Mr. Taylor, that at the time of the offense he was 15, at the time of the certification process he was 17 and a half. So if you had in the back of your mind that, oh my gosh, my client really deserves to be in the juvenile system, there's been a mistake, there's been an error here, wouldn't it behoove you to file that appeal immediately so that this issue could be resolved while he still could receive the benefits of the juvenile system?
I think that that could be a possible remedy that the legislature proposes. I think the idea that there be...
It is not something the legislature needs to propose. It's something that exists currently in our rules of practice.
If that were the case, respectfully, we wouldn't have the current appeal. The appeal is there because there was an underlying constitutional violation.
I think
Was there an attempt to appeal interlocutory?
that's the question. Why didn't you, or why didn't the defense move for an interlocutory appeal while the child was still within the tender age of the Juvenile Act, as opposed to waiting to this point where the Juvenile Act has abandoned him?
That I can't speak to.
Okay.
But there was not an appeal made, to your knowledge. There was not an appeal made on an
my
interlocutory
knowledge, no.
basis after the certification. Okay.
I have one other question. And if the purpose of the Juvenile Act is to offer these defendants, these juvenile defendants, the option of therapy and counseling to try to rehabilitate them out of the criminal justice system, to give them that option as opposed to being treated as an adult. On this record with Mr. Taylor, isn't the fact that he had been convicted of a lesser crime prior, had received that type of a juvenile sentence where he was in the treatment process, and despite that, the trial judge knew at the time of this certification hearing that it wasn't successful, and in fact, he had gone on to commit a harsher and more severe crime. Isn't that a factor that would support the trial judge certification in this case?
No, Mr. Taylor's past crime was completely unrelated and different in nature to this.
It was a burglary.
And the treatment that's available is different and tailored to the particular needs of the juvenile. If he were deemed to need sex offense therapy and behavioral therapy in line with that, the kind of work and attention and therapy and treatment needed is very different in nature, and it has to be considered very differently than someone who has a burglary, who has any number of other charges that could come under the Juvenile Act.
I think Her Honor was saying, or at least I interpret it as being, the fact that the child has had prior experience within the rehabilitation, treatment, and supervision of the juvenile system, and yet, despite that treatment and rehabilitation and supervision, he then committed a more heinous crime. The question is, that is a major consideration when discussing amenability during the certification hearing, correct?
Yes.
That's, in essence, what Her Honor was saying.
Yes, I would point out, though, that looking at that record, it did say that Mr. Taylor did well during treatment and still was amenable to treatment. There was nothing saying that any kind of future treatment regarding, again, sex offense therapy, whatever would be appropriate in that setting, was not something that he would do well with or succeed with. He had done well in placement, he had done well in treatment in the past. So those are still considerations that then need to be made when looking that, yes, he has had some level of treatment in the past, again, not to the specific type of crime or type of behavior.
Right, so the question becomes, what is your argument with regard to harmless error?
There's a structural error here. The harmless error analysis doesn't apply. The error that occurred goes to the framework of the proceeding and the fundamental fairness of what's going on here. There's no way to construe a violation of his Fifth Amendment right that then moved him from a juvenile system with a focus on rehabilitation, where he had multiple years still available to him for treatment, for rehabilitation, for supervision, to then being in an adult system where that is no longer the goal, no longer the focus, and where he's been incarcerated for an exceedingly long period. There is no way to say that's the kind of de minimis effect or impact that could be harmless error.
Well, agreed, I think, on one prong of the harmless error analysis, but going back to Justice Mundy's question, why don't we also look at whether there was the record in totality to figure out whether the evidence was overwhelming, disregarding the prejudicial evidence, which, you know, I think you have a very good argument that this was prejudicial error. Nonetheless, the fact that your client had carried a burden to establish statutory factors and only established at best 2.
So when you look at that framework in which the certification proceeded and involved a right that's not designed to protect his defendant from just erroneous conviction, that's designed to protect some other interest, like the fundamental legal principles that he can protect his liberty or not speak against himself. When you look at those pieces and you look at this cumulative effect that really falls under trial error as opposed to structural error, even that doesn't add up. There's not, in this non-exhaustive list of factors to consider for certification, any kind of rubric that says we afford this much weight to this factor, this much weight to that factor, and so forth. Now, if, as you pointed out, if you look at the certifying judge's opinion, the vast majority of it, I believe it is more than half, is focused solely on the amenability and the fact that Mr. Taylor did not admit to guilt. He made no admission. So even under this idea of looking at the cumulative effect, one, we can't guess what Judge Smythe's balance was in terms of pure numbers, but when you look at that opinion and you look at where the emphasis is,
well, but I think
there's an overwhelming point there that he's looking solely at this issue that should not have been permitted.
I don't necessarily disagree with you on that. I guess my question is, let's disregard that factor, the amenability factor. What about the other factors? What evidence is there in the record that your client satisfied his burden on the other factors such that certification to the criminal division was improper?
I mean, truthfully, I don't think you can ignore that factor, but even saying that you do, if you look at that record, he did have experts speak to his amenability, he did have his history represented. You know, those factors are there not as I said, a rubric where each one is weighed in a particular way, but as guidance for the judge. The judge didn't use the proper guidance. So when you look at what he did present, there's nothing to say that he wouldn't have been certified or not certified. He had every possibility of staying there, but because the judge had an impermissible consideration, that is what pushed it over to certification.
I have an issue with your statement that this was structural error. For what legal proposition or what legal citation can you give me for the fact that in this proceeding this was structural error?
If you look at any number of cases that describe structural error, throughout our brief we've discussed Fulminante, McCoy, and then JMG.
JMG had nothing to do with a juvenile proceeding. I wrote the case. It was about a psychological patient relationship and the proceedings therein.
Right, but when you look at the structural error, and you are correct, and of course you're correct because you wrote it, you know, there is never a direct mention of it being a structural error, but there is that framework that had this error not been made, the actual structure of the case would not have gone forward in that way. You know, JMG and Chapman look at that list that Mr. Barnes explained earlier, which again is a non-exhaustive list, about coerced confession, deprived right to counsel, deprived right to impartial decision maker, and then in JMG, the psychotherapist patient privilege for Act 21 proceedings. A Fifth Amendment violation at a certification hearing follows that line of logic completely.
Well, how can that be? How can that be that that's a structural error if in a criminal setting a person is asked about their silence prior to being Mirandized, it's not a structural error, and being asked about their silence after being Mirandized is not a structural error, and you still, in both of those situations, go to a harmless error analysis?
Because silence in and around Miranda is separate from a certification hearing where a juvenile is being moved to an adult court on the basis of not having admitted guilt in what's not a fact-finding proceeding. A certification hearing is purely to determine whether it is more appropriate for that defendant, that child, to remain in the juvenile court or if they need to move to the adult court. So a structural error there where the Fifth Amendment violation affected the framework.
And I think the district attorney's argument was that there was 7 to 10 factors considered on this record at the certification hearing, and the only factor that you raised as an issue was the amenability factor, and you raised that through your client being forced to either admit his guilt or not being certified. But you never raised issue with any of the other factors in that record. The fact he was 15 at the time of the offense, 17 and a half at the time of the certification hearing, the prima facie case made for the offenses by the testimony of the victims, the fact that he had had prior juvenile history that was not amenable to treatment. I just have a hard time viewing that this one thing on that record had enough to move where the certification was going to go. I disagree with the other side of the bench on this.
Well, the one thing that we're pointing to is really, in a lot of cases in the juvenile court, the thing to consider. At oral argument 3 years ago, the late Chief Justice Baer pointed out that for any experienced juvenile court judge, it really comes down to, are they amenable to treatment? So looking at it as though this is one of many factors, yes, it is, but it is really the factor.
And that's why
and
it
it's not
bothers me so much. I hate to interrupt you, but that's why it bothers me so much, because I think separate and apart from this issue, the fact that that Mr. Taylor had been through the juvenile system and had been a repeat offender after they had tried to rehabilitate him weighs against your client in this harmless error analysis.
Juveniles can come before the court any number of times and still be eligible and worthy of having treatment and rehabilitation. That Mr. Taylor wasn't afforded that because the certifying judge impermissibly considered the fact that he didn't admit to guilt, that is where it is a structural error. This is a fundamental constitutional error of law, and that can never be deemed harmless. If you look at Lewis, if you look at any number of cases that have been included in the brief and have been before the court.
I just have a problem with you calling it structural error, because there's been no other court other than the Superior Court of Pennsylvania that's ever niched it in that category. And you don't have a case on point to convince me, I don't believe, that it's a structural error.
Respectfully, there's not a case on point because you kind of have to have the sun, the moon, and the stars align in such a way for these facts to come up. This happens to be that case. This is the time for that decision. But again, I believe that the court can look at this as being a prejudicial, harmful error and reverse based on that without even going through a harmless error analysis, if the analysis is necessary. But
Which
again,
was Chief Justice Bayer's position in Taylor, correct?
Yes, Your Honor.
All right, anyone have any other questions? Does anyone have any other questions for Ms. Silver? Well done from both attorneys. We'll give it due consideration. Thank you. And Mr. Minner, we will adjourn to our administrative session.